Hi, my name is Agilesh and my metric number is 28351. Now I'm going to talk about question 1. Summary the background facts of for case given. The case summary. Bank Pembangunan Malaysia Berhad versus Ibu Kota Realty Center Berhad and Lo Chik Hong. In this case, Bank Pembangunan Malaysia Berhad, the plaintiff, sought a summary judgment against Ibu Kota Realty Center Berhad, the first defendant, and Lo Chik Hong, the second defendant. The plaintiff provided two loan facilities to the borrower, with both defendants as sureties. The first loan, called the first facility, was a term loan facility for up to 75 million. The second loan, called the second facility, was a credit facility of up to RM 55 million, equivalent to 48 million USD. The second facility was divided into three parts. The first one is Term Loan 1 TL1 of RM 22.28 million. The second one is Term Loan 2 TL2 of RM 15.2 million. The third one is Revolving Credit RC of RM 18 million. The first facility was for acquiring machinery and equipment for producing ductile iron pipes. The second facility had three purposes. Firstly, TL1 was for buying additional plant machinery and equipment. TL2 was for construction a TNB power substation. And the third purpose is RC was for purchasing raw material for the project. To secure the first facility, the plaintiff and the borrowers signed several documents including a letter of offer dated December 8, 2016, and second one is a letter of changes dated February 13, 2007, and the third one is a term loan facility agreement dated May 23, 2007, and the last one is the two debentures issued in 2007. The borrower breached the loan agreement, so the plaintiff sought to collect the guarantee from the defendant. The guarantee document showed that the defendant had no valid defense against the plaintiff claims, and there were no issues to be tried. Therefore, the court granted the plaintiff a summary judgment. Thank you.
Hi and good day, Doctor. I'm Anjali Rajamohan with Metri number 285428. Would like to continue the presentation regarding the issue raised by the defendant. First and foremost, the issue raised by the defendant is the demonstration of principle and calculation methodology. Basically, the plaintiff failed, according to the defendant, to provide a clear explanation of the concept and procedures used to determine the unpaid sum as requested. They maintain there was a lack of clarify about the calculation and application of the effective cost of fund, which is known as ECOF rate, in the plaintiff's notice of demand and notice of termination as well. The plaintiff's claims were difficult for the defendant to confirm and acknowledge, since the methods and assumptions used to calculate the required amounts were not clear. The second concern that raised by the defendant is the failure to inform of changes to ECOF rate. Basically, the plaintiff failed to notify the defendants of the changes in the ECOF rate, which the defendant said was crucial for determining the loan interest rates. The defendant claimed that their consent was obtained before the ECOF pricing changes took place. They argued that the plaintiff's omission caused doubt on the amount claimed, since the defendants were not informed of the rationale behind the interest rate rises and also the impacting their liability as well. Besides that, the third concern that raised by the defendant is the liability appointment to the other securities. Basically, the defendant contended that the plaintiff's other securities should be evaluated in addition to their own liability. They argue that the plaintiff ought to allocate the responsibility among all stocks that the plaintiff has acquired. This suggested that the plaintiff should account for the proceeds from the other security used as collateral before holding the defendants liable for the unpaid amounts. The defendant made hints that the plaintiff could have already received the certain sums from other securities, which would correspondingly reduce their liability as well. Last but not least, the appointment of receiver manager and the disposition of security is the another issue that raised by the defendant. The plaintiff had designated a receiver and manager to supervise the distribution of the security held as a collateral according to the defendants. They said that in order to bring a case against the defendants, the plaintiff need to have a completely disposed of the securities. The defendant hint that the plaintiff shouldn't be allowed to seek the remaining sums unless the securities were fully realized and accounted for. This issue basically demonstrates that the defendant's view was the plaintiff had not used all avenues for the collateral recovery before requesting further money from the guarantors.
So, for the question 3, I'm Dineshwari with matrix number of 287870 will explain about it. To determine if the plaintiff has the right to enforce the guarantee provided by the defendant due to the loan facility being in default, we need to examine the terms of the guarantees and the applicable legal principles. Based on the provided case study, there are several key points to emerge. The plaintiff can enforce the guarantee provided by the defendant due to the loan facility being in default. The principal debtor clause establishes the direct ability of guarantors, while the non-discharge clause ensures the obligation remain under all the circumstances. The enforceability provision allows for direct action without exhausting other remedies, and the conclusive evidence clause simplifies enforcement based on financial statement. Thus, the plaintiff can proceed to recover the outstanding amounts from the defendants, underscoring the robustness of the guarantee and the plaintiff's clear right to enforce them. Now, let's delve deeper into each of the key points. Firstly, the principal debtor clause. The principal debtor clause states that the guarantors are liable as principal debtors, meaning their liability is independent and not contingent on the borrower's default. Specifically, Clause 3 of Defendant's 1 guarantee specifies that the corporate guarantor's liability is as if it were the principal debtor, reinforcing the direct responsibility of the guarantors and allowing the plaintiff to seek repayment directly from them. Secondly, the non-discharge clause ensures that the liability of guarantors remain unaffected by any changes in the agreement between the borrower and the lender, including variation in terms, renewal, or additional securities. The guarantees by Defendant 1 and Defendant 2 explicitly state that their liabilities are not discharged by any changes or absence of enforcement of other securities, maintaining the enforceability of the guarantors under varying circumstances. Next, the enforceability of guarantees. The enforceability of guarantee provision allows the plaintiff to enforce the guarantees without exhausting other remedies. Clause 7 of the corporate guarantee specifies that the guarantee is enforceable irrespective of steps taken against the borrower or other securities, expediting the recovery process by targeting the guarantors directly. Next, the conclusive evidence clause. The conclusive evidence clause establishes that the statement of account or certificate of indebtedness provided by the plaintiff is considered conclusive evidence of the debt unless the guarantors can show manifest error or fraud. This strengthens the plaintiff's ability to enforce the guarantees based on the documented amount, simplifying the process. Lastly, the court's findings. The court findings concluded that the plaintiff has the right to enforce the guarantees without exhausting other securities or remedies. The guarantees are deemed additional securities enforceable despite any variation in the long terms, confirming the plaintiff's ability to proceed against the guarantor based on the existing contractual agreement and legal provision.
Hello everyone, I'm Avilasri Ramachandran, metric number 287525. Now I will continue presenting question 4, which is, do the defendant have the right to contend plaintiff when the plaintiff failed to inform the defendants on the changes of the rate which they claim that the changes were outside of their knowledge and concern? Give your opinion. So, in briefly, I can answer that if the defendant can demonstrate that the plaintiff did not notify them of changes to the interest rate and that these modifications were made without their knowledge or permission, they probably have the right to contest the plaintiff. In more details, I can explain that when assessing the term of a contract, courts frequently consider both express and implicit responsibility. The plaintiff may still be required to notify interest rate changes even if the arrangement does not specifically require it. This is because the plaintiff is still subject to the implied duty of good faith and fair dealing as well as the reasonable principle. The court's conclusion in this case indicate that the defendant's position was not supported by the contractual framework, underscoring the crucial significance of precise contractual language and comprehensive documentation in financial agreements. The court decision in this instance, however, suggests that it concluded the guarantee arrangement was legitimate and enforceable, and that the plaintiff had not broken any provision pertaining to notice of interest rate adjustment. Now we will quickly look at the possible defenses available to the defendant. First, violation. A breach of contract can occur if the bank neglects to inform the defendant of interest rate increase as stipulated in the loan agreement. Second is unconscionability. If the new interest rates are much higher than the initial term and were implemented without the required notice or permission, the defendant may contend that the interest rate adjustment were unaware. And lastly, insufficient informed consent. The defendant may contend that their assent to borrowing under the revised term was not freely and consciously granted if they were unaware of the modification and did not, therefore, consent to them.
So, very good afternoon to doctor. My name is Saloni Shankar and my metric card number is 28534. Defendants in the case study offered through the guarantees for the two facilities that reader gave to the borrower. The condition of these assurance specified their responsibility and also their liabilities in detail. The guarantee provided by the both defendants highlighted that they were primary debtor and not securities of the which mean by the bore full responsibility with the obligation as the top of the head had taken with the loan themselves. D1 and D2 signed the guarantees for the first facility with the key provision clause 4, indicating that their guarantees were in addition to any other rights or securities to the bank could own. This section further stated that guarantees might be enforced within the borrowers and also any other guarantee or the without using the other securities or pursuing the legal action. Furthermore, the guarantee contained provision clause 19D1 and clause 20 for the D2. They state that bank was not required to marshal any security assets. It might be entitled to the in a favor to the guarantees. So, based on the D1 guarantee made is a clear clause 3 that the guarantor has a liable as a primary debtor for the second facility. That means that anything that would not realize in the main debtor such as changes or act pertaining to the borrower's obligation would not release the guarantor from the liability as well. So with this clause in place, with the lender known as the guarantors could not back out their commitments by the modified to the other contracts or legal action. This gave back the lender confidence that guarantees would be the strong source of the security as well. So based on the independence of the guarantees liabilities from the lender activities with regard to the other securities or the borrower was significant decision of the court as well. So the lender was able to seek the payment from the guarantors without first using up all available remedies and also the other securities due to the wording of the guarantees. This implies that regardless of the ongoing efforts to realize other securities or the agreements made by the borrower as well, the lender was free to persuade the guarantors directly for the balance quote since it offers a clear dependent path to the recovery in this case. The borrower defaulted the independence is vital for the lenders. In the conclusion, the court upheld the enforceability of the guarantees provided by the D1 and also D2, emphasizing their liability as a principal debtor. The court rejected the defendant's argument that their liability should be appropriated based on their other securities and also the lender action should be affect the obligants. So the court found that terms of the guarantee were clear and also binding, and that the defendants had agreed to be liable to the principal debtor make their obligation unaffected
and also by the variance of the action taken by the lender concerning about the securities and also the borrower. This decision underscores the importance of the explicit term in guarantee agreement and also reinforcement in the principle that guarantees can be held directly liable to the debts they guarantee regardless, which is to the lender actions with the respect of the security of the borrower as well. That's it from me. Thank you.